Hello, my name is Billy Hall, and this is my sport law project. And the case I picked was Bierman versus University of Notre Dame. So, kind of just a case overview. The plaintiffs are James and Christina Bierman, defendant, University of Notre Dame, and the court is the Court of Appeals, which is where the case ended up being after the Biermans appealed the initial ruling, and then win on September 22nd in 1983. So personal interest, why it really interests me is I'm a big football fan. I go to a lot of football games. I kind of see stuff happen with fans and stuff all the time. And I never really thought about what if somebody got hurt from a fan being drunk or being, I guess, acting out of the norm, I should say. And this case really opened up my eyes to that, and that's why I really kind of just fell in love with this case. So then professional usefulness is, whether I decide to be a football coach or an AD or a open my own business, kind of just open my eyes to the liability that it all takes. Like that, if something happened that's from a third party, like what you could end up being liable for just from owning or, being the head of the departments and stuff like that. Research process was really easy. Kind of just looked up the case and then looked up rulings and what different stuff meant along the lines of the case and kind of like the rulings and kind of what happened when, I'll kind of get into what happens in the case, but kind of just like as the kind of case unfolded, kind of just looking up different things, what different things meant along the way. And research findings, I found pretty much everything that had to do with anything with the case fairly easy. Was able to find, multiple stuff that really kind of opened up my eyes and kind of raised an eyebrow about the whole thing. But suggestions for future research would be to kind of have where I kind of struggled with was stuff I really wasn't sure like what it meant at first, and then I kind of just went and looked that up. So suggestions would kind of just be to have if you do that, go and look those things up that you don't know. Go and look them up immediately as soon as you find that, so you don't get confused later on and trying to have to go back. On to the next slide. So kind of just the basis of the case, So Christina suffers a broken leg. She is leaving a Notre Dame football game, returning to her car, and kind of like her and her husband are walking back, and they seen two drunk people fighting. Well, and as it kind of the men kind of went their separate ways, and one of them kind of passes them. Well, then a short time later, man comes back and falls down into her from behind. Knocks her down. She breaks the leg from the fall. And so what they decided to do was they decided to sue the University of Notre Dame for damages resulting from the injury. And what kind of gets Notre Dame here is there was no security people in the area. So there was no ushers kind of directing people moving. There was no, kind of just security people around the parking lots, outside the stadium, nothing really like that. So, and what kind of raised my question, or my eye about it, was the Biermans left the game early. They didn't wait till the full ending of the game. They left the game early. And we go on here to the next slide here. So, Bierman argues her main argument through the entire thing was that she was a business entity of the university, and that Notre Dame was responsible for her safety. And she just said that Notre Dame owed to her a duty to protect her from injury caused by acts of other persons on the premises. So, and then Notre Dame argues that absent notice or knowledge of any particular danger to her, that the university cannot be held liable for the acts of a third person. And then another case ruling had said, like another case which was Hammond versus Algaretti in 1974, ruled that before liability may be imposed on the university, it must have actual or constructive knowledge of the danger. So then it kind of comes back all around after the whole thing goes about and kind of just is determined that, most major universities are aware that, they're selling alcoholic beverages at games. People are tailgating in the parking lots. People are consuming alcohol from 2 hours before the game till throughout the entire game. So basically, you're going to have drunk fans. People are going to be intoxicated. Stuff that you don't want to happen is going to happen. And that's kind of what gets Notre Dame here, is because they knew they were selling alcohol. They knew people were tailgating, and they knew people were going to be intoxicated. So the trial court, initially where the case first went, decided in the favor of Notre Dame. Then after the appeal, the Court of Appeals decided in favor of the Biermans. And it all goes back to the university is aware that alcoholic beverages are consumed on the premises during and before games. They're also aware of the tailgates that go on in the parking lots and around the stadium. And tailgates are wild. Tailgates get crazy. And, everybody's out there having a good time, drinking, eating, playing games. And even though the university had no reason to know of that particular danger happening to Miss Bierman, it had reason to know that there might have been somebody intoxicated in that general area, and that could have been a general threat to her. And then it comes back to also that she was an invitee of the university. And so, rolling off the Corey versus Ray case in 1944, the operator of a place of public entertainment owes a duty to keep the premises safe for its invitees. And that right there is where they really get him, because she was a business invitee, and they knew alcohol was being sold, and they didn't have security people in the parking lot. So at the end of the day, when it all comes down to that stuff, then Notre Dame was in the wrong. Now, at first, and what really opened up my eyes, I go to games all the time, and you see all that stuff, and I would never think that if I got hurt from something like that I could make a motion to sue the university. Kind of never really had thought about that until this case. And that is the end. Thank you. My name is Billy Hall, and this is my sports law project.